I'm often asked about the time frame for divorce proceedings. In a contested case, it takes time to get to a final divorce hearing, a year or more depending on the estimated duration of the trial. The period between the date you file your divorce proceedings and the final hearing date is called the provisional stage of the case. A provisional judgment is generally meant to preserve the status quo, or situation that existed prior to the proceedings, in terms of custody and money, as much as is possible. It involves a full-blown court hearing with testimony and cross-examination. What a provisional judgment does not do is divide property or compensate for the inequities of the marriage. This is done exclusively at the final hearing. Because a provisional judgment is by definition temporary, the final judgment, in theory, can retroactively redress any injustices caused by the provisional status quo. It is also important to understand that it can take time to get a provisional hearing and judgment. If there is an urgent situation that must be dealt with immediately and cannot wait, it is always possible to request an interim or safeguard order that will apply pending the provisional hearing. A safeguard order can be obtained on a few days' notice. The court will base its decision on affidavits and the oral representations of the attorneys based on those affidavits. There is no testimony. The best way to understand when to request a safeguard order is to metaphorically envision a fire burning that must be put out immediately and cannot wait. The best example is the necessity to ensure that the custodial parent has enough money to buy groceries for the children at the outset of the proceedings.